Good evening and welcome to Florida Criminal Law. I'm your host, Stephen G. Cobb. Today we're going to talk about a very important aspect of Florida criminal law, and this is the types of defenses as they relate to sex offenses. Now, Florida has multiple different types of sex offenses, and where we're going to start is with capital sexual battery. This is sexual battery under Florida Statute Section 794.011. And a key difference about capital sexual battery is simply this. If someone enters a plea of no contest or guilty to the charge, the minimum sentence is life in prison. Now, if someone is found guilty at trial, the minimum sentence is life in prison. So either way, this is one of those cases where it's almost certainly going to go to trial, so we need to consider the types of defenses. Now, the way I'm going to explain in this entire series on sex offenses is give you real-life examples from actual cases I have defended, either by myself or as part of a team. And if you've been watching my videos, at this point you know I firmly believe that superhero lawyers do not exist, and that the modern way to defend any kind of case is with a litigation strike team, because the system is the secret, not some individual lawyer's ego. So with that in mind, I'm going to take you back to an early capital sexual battery case and give you some factual background in order to go over the defenses. To begin with, this particular capital sexual battery case did not involve a parent figure such as a father or a mother. It involved a family friend who was residing in the household. Now, of course, I'm going to use anonymized information with names because that's appropriate. And we'll call my client John Doe. John Doe was accused by not one, but two children under the age of 12 of inappropriately touching them with his fingers and using them to penetrate their vaginas. The state promptly did an investigation, as they should in cases like this. The Department of Children and Family Services was involved, although at this particular time it had a different name. And sure enough, the medical examination of the two children showed that each of them had what are known as notching around the hymen, and the hymen was intact in neither child. Both of their hymens had obviously been penetrated. So here we had a situation where we had what is known as corroborating medical evidence. And in fact, a doctor took the stand at trial and testified that these children did not have injuries and marks to their genitals which were consistent with being sexually battered. In fact, the types of injuries observed were specific to sexual offenses. So we had that kind of evidence against us. Now, at the same time, my client had not made a statement to the police. This is critical because quite often when these cases arise, one of the first things that people do is they try to tell their story. This is an absolute disaster, and he was one of the few people I've represented who was charged with a major offense like this, who took a dose of shut the heck up and asked for a lawyer when he was asked to give a statement. It took us about a year to get this case ready for trial, and based on the severity of the case, no matter what I said to try and get this man a bond, it was denied. In these types of cases, it's not unusual for a judge to deny bond. Well, we proceeded to trial and we picked a jury. And this is where psychology actually plays a key role. I knew, for example, that all of the witnesses against my client would be female, except for one, and that was the father. I knew that he would give testimony that actually might help us a little bit, but the state still had to put him on as a witness for a variety of reasons. Next, I also did not have my client testify. Generally speaking, in a sex offense case, you don't want your client to testify. And then finally, since women tend to believe men generically rather than other women, this is why I intentionally made sure that we had all women on the jury. Now, during the case itself, the reason we won was a very simple defense. In criminal defense law, this is known as SODIT. What the heck is SODIT? That means some other dude did it. And that's a very common defense, whether it's burglary or whether it's capital sexual battery, which this case was. In this particular case, one factual wrinkle made a huge difference. Both parents were so negligent and so dysfunctional that by the time the case came to trial, both, not one, not the other, but both parents had their rights involuntarily terminated by order of the court due to a wide variety and series of acts of neglect and mistreatment of their own children. Therefore, during the trial, the reason we won was simply because, one, we had psychology in our favor by how we picked the jury, and two, this was a case where a SODIT defense worked because we knew that there were going to be a series of witnesses testifying about what the children had said. We also knew that there was going to be medical evidence. At the same time, there were no admissions by my client to law enforcement or anyone else. And finally, it was pretty clear that the father could have actually been the perpetrator. As a result, he was found not guilty at trial. In a wide variety of circumstances where it's clear through medical evidence that some form of sexual battery or sexual assault has occurred, it may be useful and it may be a good idea to go with a SODIT defense. So when you're looking to hire a lawyer, one of the first types of defenses you're often going to hear about is this type of defense, even if it goes by a different name. If you have further questions about sex offenses generally, feel free to give me a call. I'll be happy to answer your questions.